Needful with your electronic devices. There's apologies from Stuart Dixon, and other members will be arriving in due course. The draft minutes of the meeting held on the 4th of June are available for members on pages 5 to 10 of the folder, and if you're content that they're accurate, then I'll sign them accordingly. Okay, thank you. Some matters arising. There's a number of work items have been rescheduled by the department for different reasons, and the forward work programme for June and July has been updated accordingly. Briefing on the principles of the Justice Bill has been rescheduled from today's meeting until the meeting of the 18th of June, as following consideration by the Executive at its meeting on the 5th of June, it will now be introduced into the Assembly on the 16th of June. The Home Office recently have been liaising with the Department on the Serious Crime Bill, which will introduce a number of amendments to asset recovery and serious crime prevention order legislation, together with a range of diverse issues on computer misuse, female genital mutilation and drug misuse. Some of the issues are reserved, but many of them are devolved. For the majority of the proposals, the Minister wants to maintain current parity with Great Britain and is of the view the most effective way to achieve this within a reasonable timescale is by way of a legislative consent motion. A written briefing on the potential LCM is scheduled for the meeting on the 2nd of July. So it's for members to note that there's going to be a written briefing coming to the committee on the 2nd of July. If members are wanting an oral briefing on the possible LCM being used, then we can do that. But at this stage, we'll get a written briefing, and obviously members will have some views at that meeting. Also then, there's an oral briefing requested by the committee on the budget position, the June monitoring round and the saving delivery plans, and that's been scheduled for our meeting on the 18th of June, and officials will be attending on the 2nd of July to brief the committee on the withdrawal of funding from the RUC George Cross Widows Association. Representatives of the association have also been invited to brief the committee on the issue. So the forward work programme is there for members to note unless there's any other comments around it. Okay. A note of the informal meetings which took place on the 27th of May with the Northern Ireland Safety and Life Skills Education Partnership, Play Board and Autism NI, and the possible follow-up actions are at pages 19 to 24 of your meeting folder, and it's just for members to agree the actions as recommended in the note of the meetings. Members content to do so? Content. Item 3, correspondence from Judge Desmond Marrinan. We received correspondence following the oral evidence session with the Lord Chief Justice on the 4th of June. The relevant papers can be found at pages 25 and 26 of your meeting folder, and also 3 and 4 of the tabled pack. And correspondence has also been received from Mr William Young following the oral evidence session with the Lord Chief Justice. Correspondence can be found on pages 5 and 6 of the tabled pack. So at this stage, members, I'm asking that we would note the correspondence from Judge Marrinan, and will advise both him and Mr Young that we'll be undertaking a review of the judicial appointments policy process. So the terms of reference are being prepared for that review that the committee is going to conduct. I would be of a view that I think if Judge Marrinan is agreeable, he may well be an appropriate person to call again as part of our formal review into this process, and it would be at that stage that we may well ask him to come back, as opposed to necessarily doing it immediately on the back of the evidence that's received. So if members are content, we'll note that information. Okay, item 4. Officials are here to outline the results of the consultation on placing the Northern Ireland Prisoner Ombudsman on a statutory footing and the Department's proposed way forward. So if officials want to step forward. The relevant papers for members are at pages 28 to 78 of the meeting folder. And can I welcome Karen Pearson, Deputy Director of the Reducing Offending Division, and Anne Conaghy, Head of Probation Unit in the Reducing Offending Division, both from the Department of Justice. You're both very welcome to the meeting. As usual, we'll record it by Hansard, and then that will be published in due course. So, Karen, I'm going to hand over to you at this stage.
Thank you. Thank you, Chair. We're grateful as always to have the opportunity to present to the committee the outcomes of the consultation on the proposal to place the Prisoner Ombudsman for Northern Ireland on a statutory footing. We've provided a paper which we hope the committee has found helpful, and obviously Anne and I will be happy to take questions. This proposal was first put forward in 2008 prior to the devolution of justice powers, and the review of the powers of the prisoner ombudsman became a commitment in the Hillsborough Castle Agreement in 2010. The prisoner ombudsman's office has two main functions. Firstly, to investigate and report on complaints from prisoners and their visitors, and secondly, investigating and reporting on deaths in custody. The independent investigation of complaints is really important to us. It provides prisoners with a way to express their concerns, but it also provides the prison service with a valuable source of feedback on how it delivers its services. When handled well, complaints help the prison service improve its services and reputation, and can save time and money that might otherwise be spent on issues escalating. The Ombudsman's responsibility for investigating deaths in prison custody helps fulfil and protect human rights in the context of Article 2 of the European Convention. Turning to the consultation, that was launched in January and we received 9 responses, broadly supportive of the statutory footing approach, with some recommendations for a different way forward compared to the one we initially recommended. The Department's proposals, which would come forward in the Fines and Enforcements Bill, will not alter how the Ombudsman conducts his business on a day-to-day basis. No changes to the Ombudsman's remit are proposed, but the statutory footing would underline the Ombudsman's independence. The legislation would provide the necessary and robust framework for the continued operation on an entirely independent basis from the prison service. The key points that are set out in our paper, I'll just summarise those briefly, Chair. The Ombudsman will continue to be accountable to the Minister of Justice, but will be entirely independent of those he investigates. When originally created, the Ombudsman's office sat within the prison service, but it was quickly recognised that it needed to sit outside NIPS and at arm's length from government to maintain and demonstrate the independence of the office. The reporting structure will continue to be completely separate to the prison service. Some powers will be necessary to underpin statutory footing. The precise detail will be set out in the draft legislation, but our general intention is to legislate for replicating the existing administrative arrangements. Statutory footing will also help underpin exchanges of information with relevant organisations. And our proposals seek to create a statutory office without adding significantly to costs. The Ombudsman's office will be operated entirely of the prison service, but we don't envisage it would have full NDPB status. The Ombudsman will, however, need flexibility in his methods of staff recruitment through the use of seconded staff and shared services, but it's vital that the Ombudsman has the final say in who goes into his office. Although there will be no changes to the Ombudsman's remit, we will be proposing transitional arrangements to ensure continuity in the operation of his office for a period of time. We'd also like to take the opportunity to alter the name to Prison Ombudsman to reflect the fact that in his role he neither defends the body being complained nor does he champion the complainant, and we think this will further enhance his independent position. That's a very brief summary of our proposals, and we're very happy to take questions. I would just add that we've kept the Ombudsman up to date on our thinking so far, whilst keeping appropriate distance between us so that he can comment to the committee if you would wish him to do so. Thank you very much.
Right, Karen, thank you very much. I suppose the key question for me is if the statutory footing is purely about underlining the independence of the body, is it really necessary?
The consultation process, Chair, is a very good question. The consultation process, there was support for a statutory footing. The Minister thinks it would be a good thing to do to further enhance his independence and to underline his distance from us. But it won't change very significantly in any way anything he does on a day-to-day basis.
One of the issues that had been mentioned to me when I met with the current prisoner ombudsman was that this statutory footing would help for other departments to share information. Is that an issue that the department feels is necessary to have a statutory footing of independence, that this sharing of information can be resolved, or is that not a problem?
It's not a problem on a day-to-day basis. I've not heard of any problems with the sharing of information, but the ability to share information between organisations is one of those things that just can be enhanced, I think, by setting it out very clearly. But we're not facing any problems as far as I'm aware today, no.
There's, I think, one change around looking into custody-related deaths. Slightly broadens the scope of what the prisoner ombudsman would currently look at. If the minister asked him to look at, could ask him to look at an issue.
He could ask him to look at an issue, yes. If we had an issue that fell outside the existing arrangements at the moment, I don't think there'd be a barrier to the minister asking him, but to put onto the face of the bill and other category, that would have to be very clearly understood, the purpose of precisely what that was for. Yes, you're right.
The change from prisoner ombudsman to prison ombudsman, can you elaborate just a little bit more as to why that change would be necessary?
Again, I don't think it changes anything dramatically. It's a clarity point. I think the current ombudsman would welcome the change. Prisoner tends to suggest that he is there as a prisoner advocate. That's not his role, and it's just a point of clarity.
Okay, well, just so I'm clear in my mind then, what currently is the prisoner ombudsman not able to do that he would then be enabled to do by being put on a statutory footing?
I can't think of anything in particular that would cure, because we're not facing any particular problems in the operation at the moment. It really is about, as you said, underlining his independence and his status. It's not a dramatic shift in what he could do compared to today. But I suppose in Article 2 terms, it would be good to have that on the face of legislation that we have, the statutory ombudsman, and the consultation exercise was supportive of taking that step. And previous ombudsmen also have asked for this.
I've noted in terms of the list of respondents, I don't see the Prison Officers Association having responded. Did they engage in the consultation process?
We didn't receive a response from the POA, you're correct, that's correct.
I take it they would have been advised of the proposals, but they didn't respond to it.
That's correct.
Okay. Okay. Members, Mr. McCartney.
Thank you, Chair. In terms of a date, is the legislation in place now place a responsibility on all parties to be part of the investigation? Or is that a change?
Well, at the moment, we don't have legislation that we're relying on for the operation of the Ombudsman. We think a statutory footing requires us to think about powers. So we're currently looking at the powers that Sir has, and if I can just maybe mention where those are. They're in Section 48 of the Justice Northern Ireland Act 2002. We're still looking at precisely what would be needed, but that's our starting point for our consideration. Sir has powers of entry, powers to require documents, so that's our starting point at the moment.
That would be a strengthening of the current position?
On the face of the legislation, yes, yeah. But we're not facing any problems on those issues, I would have to say. The Ombudsman is getting full cooperation.
Well, no, I would accept that, but in terms of the legislation just strengthens it, yes. And becomes a legislative responsibility rather than just people working in good faith.
That's correct.
Yeah, okay, thank you.
Hey, members, any other?
Could I just
yes,
ask one question?
Don't let them off this lightly.
Yes, there was some concern in relation to deaths in custody. It was expressed by the South Eastern Health and Social Care Trust about the prisoner ombudsman taking the lead on clinical issues in death in custody, and it considered that the Department of Health should be in the lead, given its expertise. Has that issue been resolved in any way?
Can you help me with that?
Yes, it has been resolved in that basically the Ombudsman is there to do a fully independent investigation.
Yes.
And he needs to look at all of the sort of factors that are in an investigation. So that's the prison-related factors, yes, as well as the health-related factors. And really, for it to be an effective investigation, it needs to be completely independent. So, of course, the Ombudsman is going to use the information that he gets from the Health Trust in his overall investigation, and he will use that information. But in terms of the overall investigation, he would have primacy in terms of fulfilling the Article 2 obligation
yes.
to protection of life and an independent investigation.
And you think that the health people would be happy with that?
This has been a matter of ongoing discussion with health, and I think at the moment the Ombudsman has a working protocol of working arrangements which are entirely that at the moment. So
they're satisfactory.
yes.
Yeah. Okay, thank you very much, Chair.
Yeah. Okay, it looks like you're going to escape.
Thank you.
All right, thank you very much.
Thank you.
Okay, members, obviously the department can then consider if they want to bring forward legislation in the fine and enforcement bill when it comes forward. Probably some people will say, if it's working, do you need to fix it? And the converse argument will be, well, if it's not going to change anything, then what's the opposition to actually putting it on a statutory footing? So at this stage, I'm open-minded as to the position to take on it, but I'd be... Obviously, the department will decide if they want to bring it forward.
Chair, is there any timetable in relation to bringing it forward?
Only they plan to, if they are going to bring forward the legislation, it'll be part of the fine and enforcement bill. That'll be the vehicle that they'll use to put it upon. So, when are we anticipating?
I think it's the autumn time, around about November time.
Yes.
For introduction of that bill.
Okay, thank you very much, Chair.
Okay. All right. Then we've got officials to outline the results of the consultation on the review of statutory exceptional grant scheme and the department's proposed way forward. The relevant papers are on pages 80 to 124 of the meeting folder. Let me welcome Mark McGuicken, Deputy Director from the Public Legal Services Division, and Patrick Collin, Principal Legal Officer of the Public Legal Services Division, both from Justice. You're both very welcome, and as normal we'll record this session by Hansard and then it'll be published in due course. So Mark, I'm going to hand over to you, I think, at this stage.
Thank you very much, Chairman, for your introduction and for the opportunity to present to the committee today. I'll keep my comments brief, as the details set out in the paper that the committee has before it. This includes a summary of the responses received to the consultation document together with the department's proposed way forward. The purpose of exceptional grant funding is to provide legal aid funding for representation to persons seeking to participate in certain legal proceedings which fall outside the scope of ordinary legal aid. Legal advice and assistance is already available under the Green Form scheme, and the exceptional grant scheme would include, for example, inquests into the death of relatives. Under the provisions of the scheme, the Northern Ireland Legal Services Commission can request that the Department authorise funding for exceptional individual cases. To date, the exceptional grant power has most often been used to provide funding for representation of next of kin at certain inquests to comply with Article 2 of the European Convention on Human Rights. It has also been used to provide funding for the representation of the plaintiffs in the OMA civil action. Potentially, this power can be used to provide funding in exceptional cases which fall outside the scope of ordinary legal aid, either to enable the Commission to comply with its duty under the Human Rights Act not to act in a way which is incompatible with a convention right, or to enable the Government to comply with its obligations under the law of the European Union. Under the current legislation, the Department can either direct that legal aid be provided by the Commission in specified categories of case which fall outside the scope of ordinary legal aid, or the Department can authorise funding generically or in respect of an individual case if the Commission requests it to do so. To date, there has only been one direction issued in relation to exceptional legal aid, which is Direction 1, representation at inquests. Funding for the representation of the next of kin at most legacy inquests involving deaths at the hands of agents of the state, or where there have been allegations of conclusion, has been provided under this direction. The other main category inquests which have been funded to date under this scheme involve hospital death cases. Representation for the next of kin in such cases has been authorised by the Minister following individual requests from the Commission. Exceptional grant funding was considered as part of the Access to Justice Review, and its report contained a number of relevant recommendations. In particular, it recommended that the Minister should no longer have any decision-making role in the grant of exceptional funding in individual cases. The Minister accepted that recommendation and, recognising that the existing arrangements had been in operation for 7 years, commissioned a review of the scheme. The review focused on 4 particular areas: the delegation of discretion to vary or waive the financial eligibility test, the definition of the term immediate family and the application of the financial eligibility test, the remuneration payable to legal representatives, and the scope of proceedings included under Direction 1. With the agreement of the Committee, the Department undertook a targeted consultation to seek views and inform decisions on the way forward. 5 substantive responses were received to the consultation. Overall, the responses to the proposals in the consultation document were positive, though with some suggestions in terms of implementation. In light of the positive responses, the Department proposes to proceed as follows. Decisions on the grant of exceptional funding in individual cases should be the responsibility of the statutory appointee at the head of the legal aid delivery organisation. In practical terms, we propose implementing the change in line with the establishment of the proposed Legal Services Agency. This will be provided by the new Article 12A provision to be inserted into the Access to Justice Northern Ireland Order 2003. Once this arrangement is in place, appeals against decisions not to grant funding or further funding in individual cases should be heard by an independent appeal panel, and this will be provided by the new Article 12A provision to be inserted in the 2003 order. The statutory appointee should be given discretion to vary or waive the financial eligibility test, so removing this responsibility from the Minister. This will be provided in Civil Legal Services Financial Regulations to be introduced under Article 13 of the 2003 order. The meaning of the term immediate family should be redefined to address issues where an adult has died without a partner and where potentially parents, children and siblings are involved, and to clarify the application of the financial means test in such cases. This will be provided under the Civil Legal Services Financial Regulations to be introduced under Article 13 of the 2003 order. There is a need to reform the fee structure for inquest cases funded under the scheme. However, rather than look at this in isolation, it will be taken forward as part of the wider reform of civil remuneration. When the responsibility for the grant of exceptional funding passes to the Legal Services Agency, decisions on requests for exceptional funding for categories of case falling outside the scope of ordinary legal aid will rest with the Director of Legal Aid Casework. This would include inquests into deaths which occurred while the deceased was detained by the state under the mental health order. The new Article 12A provision to be inserted into the Access to Justice Order 2003 will also provide a mechanism to fund cases of this nature. Potentially, the Department could also issue a direction to the Director of Legal Aid Casework in broadly similar terms to the current Direction 1, but with the scope of the direction also covering this class of case under the mental health order. As I have mentioned, the provisions to transfer the decision-making on application for exceptional funding in individual cases from the Minister to the Director of Legal Aid Casework in the proposed new Legal Services Agency is contained in the Legal Aid and Coroner's Courts Bill. The other changes required can be provided for in secondary legislation, which will come before this Committee and the Assembly. The Bill provides the legislative mechanism for the introduction of independent appeals panels to consider appeals, and the role of the panels will include appeals against the refusal of the award of exceptional funding or further funding in individual cases. Further detail on the outcome of the consultation is set out in the post-consultation report. I'm happy to address any questions that the committee might have on the outcome of the consultation and the department's proposed way forward.
Okay, members. Obviously, in terms of taking this forward, as Mark indicated, some of the proposals we've already covered in the Legal Aid and Coroner's Courts Bill, and then the other mechanisms to be introduced will be by way of secondary legislation, and that obviously will have to come to this committee for detailed scrutiny. So, having said that, if there are any members who want to ask something now, you're at liberty to do so, just bearing in mind that we will be looking at this all in detail when the legislation comes before us to actually implement or not some of what the proposals contain.
Just a broad question. How many inquests would there be in a given year?
How many inquests? Or how many?
Well, just how many in general?
I wouldn't know off the top of my head at all.
No, we wouldn't have that information about the number of inquests. Of course, we can provide that, but if your question is directed to how many cases, applications for this form of funding are received, yeah, again, perhaps, if we might return to you in writing with those details.
I mean, it would be useful just when we go to that
Yes.
scrutiny of it, because it'd be just interesting to see how many inquests there actually are.
We can give you the number of inquests and then putting that into perspective, the number of applications for exceptional grant funding in relation to inquests as well, which would let you see the volumes.
Okay, that'd be fine.
Is there any figure, just when we're on that, is there any figure in relation to the cost in terms of exceptional grants?
No,
the overall cost to date?
Again, we have those details if we can provide them in written form. I mean, they are logged separately as the cases which are paid by way of exceptional legal aid, but I'm afraid I don't have those figures just to hand.
Ms. McCorley?
Yes, after Margaret. Do all inquests fall into this category, or is it just some inquests?
Into exceptional
costs.
Patrick, do you want to take
Yes. Well, potentially the scheme can cover any inquests, but the intention, because of the ambit of the ordinary legal aid scheme, with particularly for advice and assistance which we can provide in any type of matter, any type of legal proceedings, that this funding is intended to fund representation with solicitor and barrister at an inquest hearing. And the overall schemes are set up on the basis that this is intended to provide funding in exceptional inquests. Again, the nature of inquest proceedings, like some forms of tribunal proceedings, are that they're intended to be inquisitorial in nature rather than adversarial, which is a normal form of legal proceedings, whether in a civil court or in a criminal court. So potentially, yes, this funding can be provided in any type of inquest, but the scheme is established on the basis with limited funding that is targeted to fund exceptional inquests, where the next of kin would be unable to afford their own representation, and that the nature of the issues involved are such that the coroner, with the inquisitorial nature of inquest proceedings and the seriousness of the issues to be investigated in the particular inquest, coupled with other factors like whether other parties are legally represented and whether there have been other forms of inquiry into the death in question, those various criteria can feed into a question whether the inquest individually is considered to be exceptional, and whether particularly Article 2 of the European Convention would require the state to provide exceptional funding if the next of kin can't afford their own representation.
So ordinarily, in the run of inquests, you wouldn't necessarily expect somebody to be represented by have legal representation added in the nature of the event, and the provision is here for those very exceptional cases where that is appropriate in order to help get to the right outcome.
I mean, just a further question. I mean, and something I'm sure we'll teach out, but when we do describe as a normal inquest, right? Who represents the deceased? No, or obviously the family. Is that done by, say, by the coroner's office?
Well, no, not in terms of representation at the hearing of the inquest, we don't specifically speak for the coroner's service, but within the coroner's service, they have support staff who will assist the next of kin in any individual death and advising if there's going to be an inquest and what that procedure will involve. But in terms of having representation at the hearing, no, the great majority of inquest cases, as indeed, respectively, the great majority of cases in the civil courts, the great majority of cases in the criminal courts, the parties are not legally represented. But whereas it's considered that the nature of the issues involved are particularly serious, whether there are agents of the state involved in the death, whether there are serious allegations for collusion, or the other category of case which Mark referred to, particularly hospital death cases in particularly disputed circumstances, other cases of this nature, the scheme has been designed, intended to provide funding for those exceptional cases where the coroner concerned may not be able to discharge the obligation on the state to carry out an effective investigation into the death without representation for the family. But I'd say we will respectively provide the numbers, but the broad picture would be it's a small number of cases compared to the whole number of cases heard in the coroner's courts each year.
Thank you.
Just to clarify, what was the answer to Mr McGuinness's question about costs?
We don't have those figures, I'm afraid, available
Do you
today.
want to come back?
We're happy, of course, to provide them, and they are separately maintained within the Legal Service Commission's financial records, as they're broken down between criminal cases, the different court tiers, the civil cases. This is classed as a separate class of case, and we have those figures available.
Okay, thanks.
Just one technical question. In relation to the clause 3 in the coroner's bill, if the department took a policy decision not to fund certain types of inquests, is that possible?
No.
The director wouldn't be in a position to say that he thinks that's unfair, given the way the legislation is now going to be framed?
If I may answer that question, no, categorically no. As our presentation in the oral briefing to the committee in relation to the bill, if it's clearly understood, whether it's direction or guidance, they sit under legislation. They cannot override, whether that's primary legislation or secondary legislation. The Article 12A provision in the bill, the Article 12A provision in the bill to be inserted into the 2003 order sets the legislation. The guidance will sit under that, or potentially a direction will sit under that.
Okay, thank you.
Okay. Okay. All right, gentlemen, thank you very much. Okay, members, we'll move into now formal clause-by-clause consideration of the bill. And there's a paper outlining the committee's position on each of these clauses and the Hansard of the committee's deliberations at last week's meeting. Was circulated to members yesterday, and a copy can be found at page 7 to 20 of your tabled pack. Just a reminder, the Attorney-General's proposed amendment is not currently part of the bill. It will not be covered in the formal clause-by-clause consideration. The committee deliberations on the proposed amendment will be reflected, however, in the report on the bill. So, if members are clear, I will work through then each clause and schedules of the bill, and I'll need to then put formally the question on each. And where there are proposed amendments, we'll put that question on the proposed amendment first and then the clause. So if I can commence at clause 1. No issues were raised by members in relation to clause 1, which is the dissolution of the Northern Ireland Legal Services Commission. So I'll put the question, is the committee content with clause 1 as drafted? Content?
Yep.
Clause 2 is designation of Director of Legal Aid casework. Some members expressed the view that clause 2.1 could be better drafted, and they may wish to consider this further at a later stage, and the views will be reflected in the committee report. So at this stage, can I put the question, is the committee content with clause 2 as drafted? Content? And obviously the report will reflect, as I said last week.
Yes.
From some members. Clause 3 is exercise of functions by the Director. Again, some members expressed some reservations about the framework in place to ensure the independence of the Director regarding decisions in individual cases where policy constraints could impact negatively on the exercise of that independence, because a category of cases could be excluded from consideration by the Director, and whether proper safeguards are in place. And some members indicated they may wish to consider this further at a later stage. Other members were satisfied that any direction issued by the Department could not override provisions of the relevant primary or secondary legislation, and noted the requirement to follow directions and guidance issued by the Minister already exists. So again, the differing views of the committee will be reflected in the committee report, but I'll put the question: is the committee content with Clause 3 as drafted? Content. Clause 4, designation of functions of the Director. Some comments were made regarding the make-up of the appeals panels, which have been covered under Schedule 2. No other issues were raised by members in relation to Clause 4. So is the committee content with Clause 4 as drafted? Content. Clause 5 is the annual report of the Director. No issues were raised by members in relation to Clause 5. Is the committee content with Clause 5 as drafted? Content. Clause 6, the amendment of law relating to legal aid, civil legal services and criminal defence services. No issues were raised by members in relation to Clause 6. The committee has agreed to support 2 amendments to Schedule 2, which we will come to in due course. Is the committee content with Clause 6 as drafted? Content. Clause 7 is the Lord Chief Justice to be President of the Coroner's Courts. No issues were raised by members in relation to Clause 7. Is the committee content with Clause 7 as drafted? Content. Clause 8, Presiding Coroner. No issues were raised by members in relation to Clause 8. Is the committee content with Clause 8 as drafted? Content. Clause 9's application to the Crown. No issues were raised by members in relation to Clause 9. Is the committee content with Clause 9 as drafted? Content. Clause 10, supplementary, incidental or consequential provision. No issues were raised by members in relation to Clause 10. Is the committee content with Clause 10 as drafted? Content. Clause 11's repeals. No issues were raised by members in relation to Clause 11. Is the committee content with Clause 11 as drafted? Content. Clause 12's commencement. No issues were raised by members in relation to Clause 12. Is the committee content with Clause 12 as drafted? Content. Clause 13's the short title. No issues were raised by members in relation to Clause 13 as drafted. Is the committee content with Clause 13 as drafted? Content. Schedule 1's transfer of assets, liabilities and staff of the Commission. No issues were raised by members in relation to Schedule 1. Is the committee then content with Schedule 1 as drafted? Content. Schedule 2, amendments. One member expressed some reservations about the proposed make-up of the appeals panel and the intention to include laypersons as well as legally qualified persons. It was noted that the detail of the appeals mechanism, including the make-up and procedures of the panels, will be set out in subordinate legislation, which will be scrutinised by the Committee and the Assembly, with the first set of regulations being subject to the affirmative resolution procedure, with subsequent regulations subject to the negative resolution procedure. The Committee discussed the advice provided by the Assembly Examiner of Statutory Rules, indicating that the regulation-making power is of some great significance to the Bill and therefore should be subject to draft affirmative procedure on the first and subsequent occasions. The Committee agreed with this assessment and indicated that we would support an amendment to make this change. The Committee also noted the advice provided by the Examiner of Statutory Rules that the rules in respect of the assignment of solicitor and counsel where a criminal aid certificate has been granted should also be subject to the draft affirmative procedure on the first and subsequent occasions, given the significance of the powers, and the Committee again agreed with this assessment and indicated that we would support an amendment to make this change. The Department has now written indicating that in light of the Committee's decision, it will instruct Legislative Council to draft the necessary amendments. A copy of the letter has been circulated to members at this meeting. So that saves the Committee having to draft the amendments, but they'll do what we wanted. So let me then put the question. Is the Committee content with proposed amendments to be brought forward by the Department of Justice to ensure that all rules made under the provisions in respect of the new Article 36A, 36B and 38A provisions in the 1981 Order and Article 20A provision in the 2003 Order in respect of appeal panels should be subject to the draft affirmative resolution procedure on the first and subsequent occasions?
Agreed.
Agreed. Secondly, is the Committee content with Schedule 2 subject to the Department's proposed amendments? Agreed.
Agreed.
Schedule 3...
Subject to us being agreed to.
Yeah. Schedule 3 is repeals. No issues were raised by members in relation to Schedule 3. So is the committee content with Schedule 3 as drafted? Agreed. The long title, as this is the end of the clause-by-clause consideration of the bill, the committee now needs to consider the long title of the bill. Is the committee content with the long title of the bill? Content? Okay, thank you. The draft committee report on the bill will then be prepared for consideration and agreement at next week's meeting. All right, agenda item number 7. EU Regulation 606/2012 establishes a mechanism which will allow for mutual recognition in one member state of a civil protection measure ordered in another member state. To avail of protection in another member state, a person must provide a competent authority in that state with a certificate issued by an authority in his or her home member state. The procedure for enforcing the protection measures is then governed by the law of the member state in which protection is sought. Although the regulation comes into force on the 11th of January in 2015, information regarding the role of certain authorities in Northern Ireland under the regulation must be communicated to the European Commission by the 11th of July this year. This includes details of the authorities competent to receive and issue certificates under the regulation. The courts can deal with certain applications and the languages accepted for translation. The exact nature of the information to be communicated is being coordinated on a UK-wide basis by the Ministry of Justice and is not yet settled, and the Department of Justice officials are working with the Northern Ireland Courts and Tribunal Service and the Ministry of Justice on the issue. The committee will be informed of the communications to be made once this is settled. The EU regulation is directly applicable in Northern Ireland as in the rest of the United Kingdom. While no legislation is required to implement it, subordinate legislation and court rules will be required to support its implementation, and the committee will be consulted on these in due course. So it's information for members to note in respect of the current position regarding this EU regulation, or whether there's any more information that members wish to seek at this particular stage. Otherwise, we'll note it. Item 8. The Rehabilitation of Offenders Order 1978 makes it possible for many convictions to become spent and for the person to be treated as if he has never been convicted. There are, however, certain jobs and professions where applicants must always declare their convictions even if they are considered spent. These are known as expected employments or professions and are detailed in the Rehabilitation of Offenders Order 1979. They include working or coming into contact with children or vulnerable people, working in financial institutions, in the medical world and in law enforcement, amongst others, where a particular conviction could have a strong bearing on an individual's suitability for employment in that area. There has been a drafting oversight in the 1979 order arising from consequential amendments in a Westminster order that was brought forward by HM Treasury. The oversight has created a gap in the law relating to the Financial Conduct Authority's ability to take account of spent convictions in assessing the suitability of those seeking to work in previously specified positions of manager, director and controller of an electronic money institution such as PayPal and similar positions in payment institutions such as Western Union. The statutory authority to reinstate the specified positions is contained in the Rehabilitation of Offenders Order 1978, which restricts those order-making powers to the Department of Justice. The Department is therefore proposing to make a statutory rule, which will be subject to the negative resolution procedure, to correct the drafting oversight in the 1979 order and ensure that the Financial Conduct Authority can operate consistently across all jurisdictions of the United Kingdom. So it's for members to indicate if they require any more information before this statutory rule comes forward. Otherwise, we'll note that information and deal with the statutory rule when it comes before us. Item 9. The Minister has commissioned a further review of access to justice to build on the reforms which have already been introduced or which are currently being taken forward. The Access to Justice Review Part 2, which will be undertaken by Jim Daniel, will take account of progress since the 2011 review, and the intention is that it will further deliver against the Minister's vision for public legal services, which is about helping people to solve their legal problems with greater emphasis on finding solutions outside of the court process and providing a much wider choice in sourcing publicly funded legal help available to those in need. Mr Daniel will commence work during June, and his report should be available before the end of the year. The Department has provided the terms of reference for the review, which envisages a strategic approach identifying and prioritising those areas where publicly funded services are needed in order to meet human rights obligations, safeguard the interests of the most vulnerable and meet the wider public interest. The review will seek to identify both the needs which might be better met through mechanisms other than legal aid and the options which should be considered to deliver against those needs. This will involve consideration of potential delivery models and suggestions for how these models might be developed and progressed. The review will also seek to identify efficiencies, improvements in the justice system that can save resources and reduce the cost of legal aid. Mr Daniel has indicated that he would be happy to update the committee during the course of the review and to hear the views from members on access to justice. So at this stage, members are asked to note the terms of reference for the review, and if members are agreeable, that we would schedule then a briefing by Mr Daniel on progress in relation to the review, which would also give an opportunity for the committee to discuss its views in relation to access to justice with them into the forward work programme around October later this year. Members content with that approach? Item 10, the Organised Crime Task Force has been working on a new organised crime strategy for 2014-15 and it's now ready for publication. The draft strategy consists of an introduction which explains the nature of the organised crime threat and the approach through the strategy to tackling it. An annex then sets out the major strategic objectives to the Organised Crime Task Force, which it's seeking to achieve over the next 12 months, broken down into 3 areas covering action analysis, and raising awareness and outlining the aims and targets within each. The strategy group will review the strategy on an ongoing basis, seeking updates from the various subgroups as appropriate and adding new objectives as others are achieved. The Minister has indicated he would welcome any comments the committee has on the draft strategy. So if members are content, we'll note the strategy unless there's any comments that members wish to make that we could then relay back to the Department. Otherwise we'll note it. And then, if members are agreeable, we'll schedule in an oral briefing with the Organised Crime Task Force sometime in the autumn to get an update from them. If members are content. Item 11 is correspondence. There's 6 items correspondence in the meeting folder, 1 item in the table pack, and I'll draw attention to a number of them. Item 1 is at the meeting on the 30th of April, the committee considered correspondence from the Department regarding the launch of a review of the National Referral Mechanism by the Home Secretary. The committee agreed that a response highlighting the issues raised regarding the National Referral Mechanism during the committee stage of the Human Trafficking and Exploitation Bill should be prepared for consideration. A draft response to the review of the National Referral Mechanism has been prepared and it's at pages 164 to 166 of your meeting pack. If members are content with that response, then we will issue it. Agreed. Item 3 is a response from the Department to issues raised by the committee during the oral briefing session on the 7th of May on proposed changes to custodial arrangements for children in Northern Ireland. The Department has provided information on the community element of current sentencing arrangements and the success of supervision in the community and the ratio of staff to young people in Hydebank Wood Young Offenders Centre. That information is there for members to note unless there's more information required. Then we'll note it. Item 1 of the table pack is correspondence from the Department providing a copy of the Home Secretary's Modern Slavery Bill, which was introduced in Westminster on the 10th of June. The bill currently extends to England and Wales, although the Minister of Justice is continuing to engage with the Home Secretary in respect of a United Kingdom Anti-Slavery Commissioner, and members can note this position unless more information is needed. Is there any comments on correspondence that I have left out? If not, members agree to action it as outlined. Agreed. I have no chairman's business. Is there any other business? If not, then...
Chair, can I just note an apology for Mr Humphreys sent it through to me there. I don't think it was mentioned.
No problem. Okay, our next meeting is today week at 2 o'clock in the same room. Thank you.